Добрий день, шановні учасники.
So good afternoon, esteemed participants. We are starting our expert discussion. Integrity, judges, prosecutors, law enforcement, whether any unique approach is possible. And I'm pleased to pass the floor to Yulia Kirichenko. She is a member of the board of the Center for Political Legal Reforms, and he's also the manager of this project, which is implemented with support of NDI. Thank you all. I'm happy to welcome all of you, and thank you for joining our discussion. As Olga said, we will actually present two types of research. We'll talk about support to democratic processes during the war and right after the war. This project has been being implemented for 2 years. We started it after the large-scale invasion, and we are dealing with constitutional area, legal area, and we are realize that for a democracy in war, it's extremely important to support democratic processes, but they gain some different aspects. So today we'll talk about our sustainable processes. That's the competitive selection for positions. The war did not have a large impact over that, but we think that if we are talking about democracy during the war, it's worth looking at it through the prism of the armed aggression. And with this background of the Russian so-called philosophy, so welcome everybody who decided to join us. I wish fruitful discussions and positive results and positive outcomes for the people of Ukraine in particular. Our intention is to shape out the single approach to the disciplinary liability in particular, and how we can assess the integrity in particular within the field of prosecutor's office and law enforcement. Thank you, and glory to Ukraine. Then I suggest that we start our program. I'll make few technical announcements in case of a red alert. We will be watching the situation and decide whether we need to break depending on the level of the threat. And as you could see, we have some English-speaking participants. We have simultaneous translation from English into Ukrainian, so those who need it can use your headphones available on your desk. So before we start talking about discussions around the integrity, I'd like to pass the floor to Mykola Havronyuk, who is the member of the board of the Center for Political Legal Reforms, Director for Scientific Development. Will dedicate few minutes to the matter of disciplinary liability for corruption, because this is a matter that becomes more and more relevant, and it's really in the agenda on our path towards the integrity. Thank you, Olga. Esteemed colleagues, I was offered this opportunity to present this monography that has been published but just online, so we wait. It will certainly be published in hard copies very soon, but since we've already planned the presentation, I can redirect you, refer you to the website of our center, where among the section of publications you can find this quite large monograph. So let me describe in a few words what it's all about, why it can be interesting for you, and how it is relevant to our subject matter for today. And if some of you become interested, you can find it where I just said. So the idea behind this effort was based on a very simple question, whether the life exists in Mars. So indeed, the question is whether the disciplinary liability indeed exists. We talk about applying sanctions to all offenders of the legislation, including criminal liability and disciplinary administrative liability. So, of course, actually, I'm an expert in criminal law. Still, I know that the criminal law does not work. I looked at some statistics. I saw the figures. You may be surprised, those who hear that for the first time, but in criminal code there is an Article 364, which is abuse of office. So just a few years ago, about 1,000 persons per year were convicted under this article. Last year there were only 2 or 4. I mean, huge breakthrough, of course, in criminalization. So, of course, there is nothing to be happy about. So then we thought whether disciplinary liability is still in force. Maybe there is an easy way to dismiss them from their offices, to get rid of them. Why do we really need this long-lasting criminal proceedings and judicial proceedings that may take a few years? Or, as you know, Ukraine is kind of champion in delivering convictions 17 years after the crime had been committed. So, getting back to what I said, of course, it was really interesting. Maybe these perpetrators are removed from their offices through disciplinary proceedings. And I can tell you right away, no, they are not subjected to any disciplinary sanctions at all. So we identified several dozens of categories of public officials which cannot be held to disciplinary liability because they do not report to anybody, to any entity, while the appointing authority does not have any disciplinary powers. So let's start with the president. The president can be held to under any liability. I can mention many other offices like Prime Minister, etc. So there are many public servants which cannot be by law sanctioned through disciplinary proceedings at all. So I don't want to list here all the examples, but the second point is that if we talk about these categories where disciplinary sanctions are possible, such sanctions are part exclusively of the labor code. But actually, there are only 2 ways of sanctions, where the worst is the removal from the office, dismissal, or stating like as the labor law calls it, that's the strict comment, which is actually the sanction which cannot be applied to a number of categories because the law does not provide for that. These categories of officials have special status, so a reprimand is not possible at all. So the research that we are talking about consists in 4 parts. The first part is scientific, theoretical. Second part is about peculiarities of disciplinary liability for any corruption-related violations. The third part are the conclusions and recommendations, in particular for lawmakers, that we actually develop based on the results of our research. And part 4 are attachments or amendments to illustrate through the tables the context of our sophisticated legal provisions, and where we show the lists of those public officials where the disciplinary liability is applicable or not. We also give elements of disciplinary misdemeanors, for instance, and since this is the first research of this kind, we had to apply different methods, in particular comparative law, and we refer to the legislation of other countries, and we were surprised to learn that, for instance, Germany has the disciplinary code for public servants with very clear description of all categories. It's a very unified code, and it has very unified approach to the disciplinary liability and to disciplinary sanctions. And we also added a couple of laws on disciplinary liability applied to police, for example, from other countries. And just to conclude, and to move to the topic of integrity, this is a subject matter that has made recently the sociologists very interested. I mean, social scientists are trying to find out how the public understands the integrity. They actually applied the rating of 12. They decided not to use this 12-point system, but the 10-point system, which is not usual for Ukraine. And I still belong to the generation, you're all too young, of course, comparing to me, those who had 5-point system at school. So, do not tell that anybody. So, when we hear that the scale is from 0 to 10, the president is the champion because his rating is 10 points, police 4.3, courts 3.7, while the cabinet of ministers 3.3. When I applied 5 points rating, I realized that the president has 3. While police and courts are 2. We should not be promoted and even prevented from developing their careers. While if we talk about the courts by the system, the courts will have 1, which is the worst mark possible. So, actually, we thought that the only criteria applicable to public officials, public servants, is honesty. And what's the difference between honesty and integrity? Maybe it's just enough to be honest, and that's it. Thank you. Thank you, Mykola Havronyuk, for this wonderful introduction to our major topic. And I'd like to note that indeed the matter of integrity is quite complicated because that's probably suffering from the field of ethics, morale, philosophy, where we are trying to establish the scale to measure the integrity through mathematical tools. And at our center, we've been always trying to clarify what the integrity means. I remember Mykola Havronyuk published some materials on our site describing some elements of the integrity. Now within the NDI project, our expert in the area of judiciary decided to analyze the authorities that assess the integrity, what they believe to be the most not integral. So I'd like to present you this survey now. Well, thank you. Good afternoon, everybody. I'd like to start by telling about our research. So we decided not to proceed from international standards, international soft law. We decided to analyze the whole practice of assessing the integrity within Ukrainian, let's say, authorities. Thus, we will try to identify the indicators of the integrity. So actually, we have analyzed 327 of judgments or decisions where an individual was found as one who does not have integrity, or the rating resulting from the assessment was so low that they could not be appointed. In particular, we analyzed the decisions delivered by a high qualification commission of judges based on the assessments that they had conducted, and also we included here the recent competition to hold positions at the trial courts. Also, we analyzed the decisions of ethical council within the framework of the procedure of selecting candidate to High Council of Justice. Based on this analysis, we found that up to 73% of decisions included such grounds for finding an individual not integral, where the problems of legal nature, where they couldn't explain the sources of the wealth or any other episodes related to the law. So 3 out of 4 judges, potential judges, had problems with this property or assets within the competence of High Council of Justice or the Council of Ethics. So I mean, that shows that the assessment actually does not achieve the goals, basic goals, because they have to investigate instead of assessing the origin of proceeds, let's say. And also we identified 3 areas here: property-related issues, professional integrity, and personal integrity, which is related to their activities beyond their office. Well, talking about professional integrity, this ground was mentioned, this reason was mentioned in 137 cases. Situations like underperformance, failure to declare the wealth, the relatives, and for personal integrity, as you can see
особа була
that individual has been recognized as non-integral in a personnel management issues by breaking the personal integrity parameters. So that was visiting temporary occupied areas, abusing the procedural rights while applying to the court as a physical entity, not as a judge or a lawyer, but when doing some court processions as a private person or in adherence to the court rulings, so bearing to the responsibility, or the recently emerged reason in competitive selection, notification by the judge or by the candidate irrelevant data, or providing documents that has evidences of being fake evidences. So since 2016, that particular reason has not been taken in consideration as a special one, as a focused one, but since then the decisions of the ethical boards start referring to that reason as a reason to consider the person as non-integral. And within our current discussion, I would like to draw attention to the several conclusions based on the analysis made. That's the practice of evaluation in terms of possessions assessment. The majority procedures reviewing the status of property possession, the judge or the candidate for a judge job, the respective authorities demand to be a proactive. So that is not only the task for the Senior Qualification Commission or the ethical board to see the reliability or relevance or irrelevance of the documents, or that the candidate has to dismiss the concerns. And while we're speaking on non-declaration of the possession, the candidate has to give evidences that enough activities were undertaken to reflect full and truthful information in the declaration. So it's not enough, or it's not now considered by the authorities as an argument that the family member did not provide me with that information, while that information could be detected from any open source. The second sub-conclusion, that within the analysis of the property possessions of the candidate and family members, not only the sufficient funding availability is being reviewed to purchase items, but also the legality of this funding. And third, some conclusion that authorities interpret quite widely the family members while reviewing the status of property possession. The information has been reviewed not only related to those family members mentioned in the declaration as required by anti-corruption legislation, but also parents. Sometimes the reason for the non-integrity were the facts related to the property possession of former husband, wife, grandparents, nephews, nieces, aunts and uncles. So this category has been considered quite widely. And the fourth sub-conclusion, what is the issue with the property non-integrity? How do we set that threshold if individual had not declared certain items, non-declaring what sort of item, of what value, of what sort, should be the evidence that the person does not meet the criteria of integrity. Unfortunately, based on analyzed practices, there are no clear criteria, clear indicators. How do we codify that property? We were unable to detect those, but this seems to be a prospective direction, and it's worth further engagement in that area. And in terms of the property possession, the authorities pay attention to the overall or systemic violations committed by the candidate or by the judge. And while we're speaking about the declarations, obviously mistakes may take place, but if these mistakes are systemic, they were recognized as the authority as an evidence that the candidate does not meet the criteria of integrity, but not because violating the indicators or parameters, but because he was not professional enough to his professional duties, which is unapplicable for the judge or the candidate. In terms of professional integrity, we failed to draw too many conclusions. First of all, we have to separate here, while at the personnel management procedures, we separately review the issue of professionality of the judge, of the candidate, with the respective tests, with the respective rehearsals and practical tasks. But while reviewing professional ethics and integrity, we also do the assessment of integrity in professional duties. And the most challenging here, speaking about the judges, everything that relates to the court rulings and specific decisions made, because this is a very thin line when authority reviews the court's ruling and its interference in the independence of the judge, and reviewing the ethicality and applicability of respective decisions during the court rulings. And in terms of the professional integrity, once again, there are certain and separate decisions, so it's not enough for the judge to break their professional duty. It is critical that the violation of this professional duty would be systemic, so the judge would violate some provisions consciously and would not reflect the mistakes committed before. In one of the cases, the judge or the candidate of the judge has been recognized as non-integral because the disciplinary agency twice for a certain period of time has called him for liability for breaking the similar provisions. So that was one of the provisions of terminating his participation in a selecting procedure. And overall conclusions in terms of the practice that the respective authorities undertaken the assessment of integrity in the recent years deliberately follow the view that that should be the autonomous procedure. There should be a court's ruling, judge's ruling, disciplinary conclusions, National Agency on Corruption Prevention. Those all are reflected during the evaluation, but they don't have a prejudicial meaning. As I probably reflected back in 2017, 2018, the Senior Qualification Board and Senior Ethical Board had a practice that if there is no conclusion of National Anti-Corruption Agency, and then we're not authorized to review that on our own because NACP is the agency to do this job. And the second overall conclusion in the context of integrity evaluation and assessment, there is and it will exist, despite the integrity indicators we are going to endorse, it's a wide discretion of authorities undertaking that assessment. As Olga had mentioned at the beginning, integrity is not something that you can measure by points, applying a single algorithm. It's the same as we say, speaking about integrity, we start thinking about good, bad, evil, moral dimension, and so forth. So it's very critical for these authorities undertaking the integrity evaluation for judges or candidates. The members of these boards would meet those criteria on their own. And the third sub-conclusion, that in the majority of decisions which we have analyzed, there were several circumstances presented as an evidence of the individual not meeting the criteria of integrity or reducing the score, and only the ethical board, I could trace this trend, and they had mentioned that every circumstance is a separate reason to recognize this person as non-integral, or these circumstances are considered as a complex. The other authorities sometimes mention that in their decisions, sometimes not. So that is, to an extent, an obstacle to generate a sufficient criteria. And to conclude, just a very short recommendations, which we drafted as a result of analysis, that firstly, that integrity criteria should not be too generic as we originally operated in our personnel management procedures when the board been regulated by international judges, courts and standards, because that's the field for abuse, and at the same time we hardly can make these criteria too specific because the cases of non-integral behavior are enormous and you hardly can put them in a single list. That's impossible. Second, criteria for integrity and the upcoming recommendations would be relevant when the senior qualification board would endorse this. That's to ensure the regular review of those indicators or parameters, because the social relations are dynamic. There are new cases of non-integral behavior emerge, and it's critical so these indicators would meet the current social state, but this would not be frozen, endorsed decades ago. Third recommendation, at the stage of implementation of these indicators, while these to be introduced in the practice of respective authorities, it would be critical that different agencies would understand and interpret them in the same way. So, while I have not seen, maybe I have seen in one or two decisions that the respective authority referred to its own previous decisions based on the similar circumstances and enhanced its position. So our recommendation is that when Senior Qualification Commission and Senior Judge Board, Civil Integrity Board, Ethical Board, the Competitive Board, when they will start applying these indicators and parameters, they would refer to their previous decisions where they were given assessment to the similar circumstances and would explain whether they differ from their previously originated and drafted assessment and decision, or would confirm that this is a sufficient reason for considering the person as non-integral. And there also was a small proposal to refer to the decision of other agencies. We see that this is not requested by the law. It may be seen as not the most appropriate provision, but developing the common understanding by different authorities and stakeholders participating in assessment of integrity. The fourth recommendation, that's very critical, to introduce these indicators and at the first stage to conduct the qualitative analysis and finalizing the respective practice that would allow the judges and the candidates to the judges post to be clear how the specific indicators are applied and to the respective authorities to reflect on the way that had already passed. The next recommendation, and that's more technical one, that's still in the decision, which is based on the criteria, integrity criteria assessment, it was mentioning whether it's a sole and independent reason for defining the person as one that not meet the requirements of integrity, or these provisions are considered in their complexity and only as a complex that sets the reason for not applying to integrity provisions. And the next, it was working further on developing criteria in terms of the substance of integrity violation, because the fact of non-declaring assets, that could be an elite asset, or that could be a tout vehicle, a tout card that has been purchased back in 2012. From the formal standpoint, that is a violation, both cases, and not adhering the criteria of integrity. But we are clear by the substance and by the essence, these are completely different violations that should be reviewed separately. That concludes my part, and I would like to give the floor back to moderator. Thank you. Thank you, Roman, for such a profound analysis and for introduction of that analysis. So, to get closer to our subject of our discussion today, I would like to draw your attention that in the Constitution, the articles on prosecutors are included in the chapter The Justice, and it could be translated that the prosecutors are integral part of a justice system, and police authorities in many cases, in many aspects, are adjacent to that justice. So we asked a question, is it possible to apply that practice available in the court system to be applied in law enforcement agencies, in prosecutors, in police, and whether it's going to be effective and efficient to apply similar approach to generate not only the integral courts, but also the integral law enforcement agencies. And just to burn our discussion, which we're going to expand, I would like again to give the floor to Mykola Havronyuk, and we will try to set these questions and find these answers.
Шановні друзі,
Thank you, dear friends. In spite of our intention to discuss this topic today, integrity, it is not a new problem. Just recently I read a book by Prosper Ukrainian Cossacks and the Ottomans. It was written many years ago, and that's what I read there on the siege of Zaporizhia, which was stuffed with good men. Some of them still were not accepted, and they had to go through a testing. They were not supposed to present any documents to confirm their integrity or qualification. They had to prove their bravery and their mastership in arms. So when I heard for the first time the word integrity, I actually perceived it as a core in the context of verification of integrity or assessment. So I read it as we had to draft laws which would provide for any verification of integrity. I started checking literature, what kind of verifications can we conduct, because indeed, the same way it was done in Cossack troops, the people were admitted to national police, and actually you were not supposed to be integral. You needed just specific level of knowledge or education, and you're good to go. So the way they conducted these verifications for patrol police candidates was that, say, one of the officers is driving a car, starts breaking the rules and does that within the field of vision of, say, patrol police, and then this officer tempts the policeman, offering him a bribe, and the bribe is accepted, so verification is not passed. Then in 2015, I believe, 2014, the new law on prosecutor's office was adopted, and it provided for establishment of Inspector General Office, which would be in charge of verifying the integrity of prosecutors every year. And each one of them was supposed to undergo this verification. Well, we had about 15,000 prosecutors at that time. During the year one, they managed to conduct 170 verifications. They found 50 prosecutors who were not integral, and 4 or 5 of them were dismissed. Although, according to the law, if you fail this verification, you lose your job, because you are not a Cossack anymore. But now we are talking about the integrity not in the context of verification of your integrity or of those who are already part of law enforcement authorities, but now we are talking about checking the candidates to these positions. So first point we need to think about is how we distinguish between the integrity of the candidates and integrity of active officers. So if you look at the list of indicators of non-integrity, it was developed about a year ago. So all in all, you'll find 18 indicators, and out of them only 10 apply to the candidates. So again, you cannot apply all these criteria to a candidate or the active officer. Another problem is that it's not possible to assess, to evaluate a candidate for compliance with indicators which are not compulsory for many professions. We could see it during the competitive selections for positions of judges or members of High Qualification Commission of Judges. An individual can actually take this position while previously being a prosecutor or a researcher or a lawyer, but different requirements apply to these different categories, former lawyers, former prosecutors, etc. Like, for some, they are not supposed to be biased, while others are not supposed to undergo this verification by this criteria. Say, if you are a professor at the university, how can you really check whether you are objective or not? Of course, I teach at the university. I can show you in all cases that I'm always really objective. So, as of today, we have about 10 laws mentioning the word integrity without speaking about academic integrity, which is a different subject matter. In addition to these laws, we have at least 4 orders: the Order of Prosecutor General Office, Ministry of Internal Affairs, and Bureau of Economic Security. And actually, they probably copy-pasted in many situations trying to write something similar, but the results are really different, because if you look at prosecutor's order, it contains a definition of integrity and 11 statements in the questionnaire they are supposed to fill in, because every year the prosecutor is supposed to assess himself or herself by giving answers to these questions, and actually if your questions are right, then you're good to go. You have integrity. For economic security bureau, they have 13 criteria for integrity with reference to the law on civil service, although they are not civil servant. For Ministry of Internal Affairs, 5 indicators of integrity, while there are many other indicators of honesty, not integrity, and plus 5 indicators of professional ethics, meaning that honesty and integrity do not have anything to do with it. Integrity. So, and now security service of Ukraine, 5 indicators of integrity and honesty, and like 10 indicators of professional ethics. That the laws on civil service and service in local self-government, they just make it very easy. They state that the integrity is when civil servant defends public interest. What does that have to do with the public interest, or what does it have to do with honesty or integrity? Plus we have some more laws applying to leadership of special as anti-corruption prosecutor office, inspectors of High Council of Justice, members of High Council of Justice, members of High Qualification Commission of Judges, and judges. So these categories of individuals, they indeed did a good job copy-pasting. So all the indicators are very similar, they coincide while law deals with the property of related persons, but the other tells about the property of family members. Why the discrepancy, I don't know. Some other considerations that I have when I read the list of laws and criteria of integrity. The first one is independence. Well, I would agree with that indeed. That's an important characteristic. Everyone within law enforcement should have it. The next one is honesty. Okay, let it be. Then resistance to bribery. So I'm thinking, can you be honest but still take bribes? Or maybe you never take bribes, but you are dishonest. I don't know. Then compliance with ethical provisions. Again, question. You can be honest, you can be unbiased, you cannot be bribed, but you still fail to comply with ethical provisions. Then you cannot be at this office. Then, a very interesting point, the individual has to demonstrate absolutely impeccable behavior in his professional activities. Well, that's a bit funny because the behavior is impeccable, then automatically means that he's honest. Well, I cannot see here some important criteria. Having empathy, being sincere, being such that has bravery, or for instance, like they offer you a bribe and you are brave enough to reject it, would we include this criteria? Then the responsibility. If you are a law enforcement officer, you should be responsible, first of all, and at the same time you should be integral. Another surprise for me was that the whole world is guided by Bangalore principle of judicial behavior. Say, our legislation for judiciary is based on these principles. Why wouldn't you apply these same principles for integrity? Another point, in our law, we define integrity and the relevant criteria, but every year the judges have to respond to a questionnaire which does not refer to any of these criteria from the law. So, meaning that now when the judge fills in or answers the questions of the questionnaire, he or she is supposed to respectively take this approach. Well, when being a candidate to judicial position, probably his views were different. Well, now we have this complex strategic plan of the reform of law enforcement authority in the context of defense and security sector. That's the name, official name of this program. And one of the points is developed and implemented typical ethical code for law enforcement officers, which would define the principles of integrity, comma, then honesty, comma, that's something different, transparency, and a zero tolerance to corruption. So, whatever document you read, you always find different wording. There is a number of other laws, say, that describe the competitive selection for Bureau of Economic Security or National Anti-Corruption Bureau. Again, the wording are different. Head of an ACC has to be integral, competent, and capable of performing his duties. And as for candidates for police service, I already mentioned you the requirements. So from the practical point of view, when we implement all these competitive selections, competitions, the integrity probably needs to be defined as a set of some good features, and the point is, how can you make sure that you do not mention any of these features twice? Because if you fail to mention one of them, all of a sudden it may impact the future of the career of the officer. Then many institutions develop their own methodological recommendations for defining the integrity. Like I was talking about the virtues that need to be that are included. Well, actually, I used to be member of different commissions, candidate to member of commission for integrity, but I never actually managed to hold such a position, so I don't have much of practical experience. So during these competitions, sometimes they ask questions that has nothing to do with the law, methodological recommendations. One of the foreign members of such competition board started asking me, why did I need this 0.1 hectares of the land? I told him that many people have that. What do you do there? He started asking me. I started explaining that I plant trees there. And then, you know what was found? That he was not thinking about acres, not 0.1 hectare. Actually, that's a special measure in Ukraine. So just to conclude, what we need is not only to define what we mean by integrity. This integrity and criteria related to integrity should be combined and tied up to the verifications of integrity, so that the same criteria apply from the very beginning to the candidates, and also the same criteria should apply when the active officer is checked or verified. That's my point one. And point two is when we check somebody against certain criterion, we need to apply some ratings, and these ratings should be made from the points given by every board member to the specific individual, and then all of them are summed up, and we come up with a single rating. So let's say somebody has 90 points, somebody out of 100, and the system will be clear for everybody, and those who watch these competitions will have a very clear picture on who gained from what. It's like in box, you know, so In the end, it will be interesting exercise. And if any work or exercise is not interesting, then probably people tend to lose any interest to that. Thank you. To answer your question whether a civil servant can be honest but still can be bribed, I think that yes, of course he can take bribe and honestly perform what he promised to do to the bribe giver. Well, if he fails to do so, then that's a fraud. They are certainly joking. So now, to continue our discussion, I'll probably deviate from our agenda. And I will offer the floor to representative High Qualification Commission of Judges of Ukraine, Roman Sabotage, because he needs to go soon in order to apply all these indicators that we are discussing in practice.
In fact, thank you very much for things that I've heard from Roman. I will definitely have a read because it makes an interest. You did mention the tout card or expensive items. We consider the item of corruption risk if person has sufficient amount of legal incomes and is able to declare some expensive items which considered to be expensive but is quite affordable to that person. It's not because that person was keen to hide something, but maybe because when husband makes 20,000 euros legally per month and in her declaration she forgot to mention 1 million, it's not because she hid it 1 million, but because she spends or she has husband's income in that amount. So it's not because of kind of bad intention, but because it's not that relevant to her. And maybe this relevance may be an individual, and this is a real case from real life. And in terms of generosity, I would echo Olga. Of course, it could be the case when judge is generous and buy some beloved person some expensive gifts. He's generous, yes, but where money comes from for this generosity? So that's another sort of a situation. So the relevance, that could be something that we are trying to apply, and in our commissions, in our boards, we try to put that in written if possible. So we would like to get that confirmed in practice, but we still insist in the autonomy of the judges, because for different posts there could be different requirements. If it is a senior justice board, that's one case, and the other case, if we consider keeping the judge on post, I know that you may disagree with me, but sometimes we still reflect that. And in terms why that's such a big percentage of possessions, because it's easier to detect, very easy analytical tools to be applied in terms of the professionality. If someone would say it's a low level of professionality, but that's the peculiarity of the law. The law says that competences are set by the different tools, by testings, by practical tasking, and in terms of the efficiency, that's what we can detect through other tools. And quite often the professionality is being reviewed through the code of ethics. So maybe it is not reflected in the professional ethics, it's not reflected separately, but maybe reflected through the different tools, including the code of conducts. It's not a critique, not in a way, but these are the tools that we have by legislation to review different circumstances, and judges quite oftenly demonstrate the proper behavior. Very rarely we can catch the judge when the judge demonstrates improper behavior in a personal life. Judges are quite often quite restricted, predictable. They plan their behavior, they control their words and phrases. Yes, there are cases when people kind of go beyond the frames, and then the integrity put in doubt, put in question, but it is not because they are not willing to, but mainly people do meet this criteria in a private life. And again, it's very rarely when something goes wrong, and we all may recall the judge from Shevchenkov district court a long time ago who allowed some excessive things in their life, but I hardly can recall any similar cases. Thank you. Apologies that I have to run, but the public board on integrity takes time, and they spend time to review the members of committee. Thank you, dear Roman. Of course, you're released, and thank you for your comment, and we'll get back to our agenda and to discussion to what extent we can generate a single indicators or common approaches to prosecutors and law enforcement authorities, because a similar activity is envisaged by the plan, which I won't be able to name properly, so I would like to give the floor to Evgeny Krapyvin. Thank you for the floor. Greetings to participants. I don't know to what extent, but I do believe it might be possible, but at least it was trying. But I will start from digression and some comments on what has been said already. For me, the situation with integrity is interesting, because my kind of side analysis had demonstrated that for the first time that terminology in Ukrainian legislation at the level of law emerged in the law on prosecutors back in 2014, almost 10 years ago. So when this law has been enacted, so those secret review of integrity were mentioned, and if my memory serves me, back then that was the idea, maybe not personal idea, but introduced by the Bogdan Vitvitsky advice, American lawyer of Ukrainian origin who was an assistant to federal prosecutor, and he explained how that works in United States, this secret reviews, and then it ended up in our legislation. But obviously it did not result in generating the understanding what are the criteria of integrity, and that situation, I think, goes more and more, or runs, and the court system is interesting because it probably generated most of criteria which are applied in practice, what Roman had mentioned. But taking all the cases where legislation reflects integrity in the judicial system and prosecutors, it's listed in the handout materials which you have in front of us, mentioned by Mykola Ivanovich. It's a very different practice of understanding and interpreting the integrity during the secret reviews and during the certification that started in 2019 and lasts till none. National Anti-Corruption Bureau, Economic Bureau, Investigative Bureau, all the senior officials and desk officials have different approaches, and Mykola Ivanovich absolutely fairly listed that everything good, excluding all the bad, but it's quite generic. I personally, for the third year, have honor to teach the induction to the professional ethics for prosecutors in prosecutors training center. So in fact, these are the new prosecutors who are placed in the job, and they are at the moment the prosecutors interns. And my blog comprises also what to do if that area constantly reflects the very similar words, but everyone puts different meaning in it. And we speak about ethics, we speak about professional ethics, we speak about professional responsibility. At the same time, we refer to morality, dignity, diligence, and integrity. And I always was surprised that the code of professional ethics of the prosecutors requires not to be integral. It is required to be the example of integrity. And what is the difference between integral prosecutor or example of integral prosecutor do not lead to any questions. But if we see what the respective authorities do with the qualification board for prosecutors, while considering the case of disciplinary liability, also review the cases of professional ethics violation leading to non-integral behavior. There are no definition of that sort, and the third column of the board operates the ethics definition in a very narrow way, which ends up in violating the anti-corruption legislation and some external appearances of behavior in the process, obviously. And it was always difficult for me to explain to prosecutors what is the difference between integrity and professional ethics, and what is the difference between violating one and violating the second. And here we comes to what I call the instrumental approach, where we define certain criteria for us and then apply that during the assessment, during appraisals, during the reviews and other personnel management efforts. And perhaps that discussion is never ending. Each and every one would have its own view and difference between ethics, integrity, features, and proper behavior. Improper behavior. Maybe we should keep that discussion a bit aside and leave it to a scientific party, and for us to consider on some basic criteria which we've heard from the judges, maybe as a single unified approach could be applied not only during the assessment of an evaluation of judges, but also apply that in adjusting authorities, in prosecutors and in law enforcement agencies. Moreover, there is such a demand, and this demand is quite urgent. We mentioned the plan, differences in title. It's a comprehensive strategic plan for prosecutors and law enforcement reform. This is a long title, but in Brussels they said, please give us a comprehensive plan or overarching plan. So we had provided that, although in fact by its content this is a concept, this is a strategy, so it's a systemic view endorsed by the President for the nearest upcoming 3 years. How are we going to develop the prosecutors system, law enforcement branch, and in general the criminal proceeding, public order, public oversight. And while each and every strategy requires the implementation plan, we have such a governmental document which was endorsed on the 23rd of August this year, and this is an action plan to an overarching plan for the sake of a plan, but, well, it's just a title. But the idea is that for the several time it has mentioned in that integrity has to be reflected during the personnel procedures. But what sort of procedures are mentioned? Competitive procedures are to be expanded, both in prosecutors and in law enforcement agencies. So each and every managerial job has to be appointed as a result of a competitive selection, including the review of integrity. Moreover, there should be a single, or in brackets, same mechanism of review. That's what is missing at the moment, because every authority has its own view how to apply that, but it is far from being unified approach. And that's what the senior qualification board is trying to develop. That is really helpful to other authorities. And it has been mentioned the typical code of ethics or code of conduct. I managed to defend the case that it shouldn't be a separate code of conduct for prosecutors and for the judges, because the level of independence for the judge, for the prosecutor, or for investigator, they're different. But it should be a typical code of conduct for all the law enforcement officials, comprising the criteria for integrity. Again, we apply different wording here, but how we ended up with integrity in the code of conduct, that would have its own challenge while the development and implementation. But still, my key message, my key thesis is that these developments, which the Center for Political and Legal Reforms to be endorsed from the court authorities, those are to be used not only for the court reforms, but also for those adjusting authorities of the criminal justice, which I have mentioned. And maybe for the first time, these are going to be some basic criteria referring to properties, assets, or personal integrity. And then each and every authority would adjust things based on its peculiarities. But the single mechanism and single criteria, that is something that should combine these things. And here, the court experience would be most valuable. And besides the overarching plan, we have the plan for Ukrainian facilities. This is our central document, core document, that we use to regulate relations with Brussels as part of the European integration ambition. Also reflects integrity. And my personal view for many years, that the integrity discussion is obsessive here, because we have a professional ethics and we have to be based on this professional ethics. But I've changed my mind now, and probably at some instrumental level we could be advanced more by applying at the same time the category of professional ethics and category of integrity. And in the recent year, quite many things in this area were changed, and I do hope that following our discussion in the practical level, at the implementation level, we also will see some decisive steps in legalizing, instrumentalizing, and introducing the integrity terminology in the personnel management area. Thank you. Thank you, Eugene. Now we will digress a little for a short break, so we can digest, we can think through, and prepare ourselves to the more active discussion, engaging all the participants of our round table. And I also would like to encourage to our discussion the online participants. Now we will interrupt for a short coffee break, and we'll get back to the discussion at 1600 hours strict.
So we will continue our expert discussion on integrity as a tool to evaluate professionality of judges, prosecutors, and law enforcement officers. So in the first part of our discussion, I will just remind you, we looked at the experience of judicial system and implementation of the tools for such assessment or evaluation, and we looked at plans or maybe intentions to introduce the evaluation of integrity for prosecutors, law enforcement officers. I'm inviting everybody now to share your thoughts, your considerations. At our center, we'll continue working on these topics, so your suggestions will be very convenient. And first, I'd like to offer the floor to representatives of judiciary, Mykola Havronyuk. He is the head of Secretariat of High Council of Justice. Yes, good afternoon. I'm happy to welcome all of you. Of course, many of members of our council wanted to participate, but today is Thursday, and it's a plenary session day, so our council has very active operation today. So I was delegated from the council to take part in this mission. So I'd like to say that the subject matter that we are discussing, and will certainly share this information with the members of High Council of Justice, is certainly your analysis is very interesting. And as you know, our council now is working very intensively on the final part of approval of a single criteria for evaluation of integrity. That's as part of a state anti-corruption program. Also that actually meets the requirements of the respective law. There was a working group with participation of national, international experts, has been working all this time. There were representatives of the government, self-government authorities. Actually now their conclusions have been referred to the members of High Council of Justice. And of course, when we talk about this single unified criteria, probably they will be expanded not only to practices of our council, but also to other authorities, and probably we are pioneering this path. And so the value of each word, of each sentence matters. So one cannot make such important decisions quickly in an expedient manner, so it will take time, but soon probably they will be approved. Speaking about the matter of integrity, I'll tell you honestly, we have been discussing it very often, mentioned a lot in public space, and you know, they say when you repeat the word sugar many times, you will not feel sweet in your mouth. So we say again and again the integrity, and my impression is that this word seems to lose its meaning, and so everyone now is talking about integrity. So many articles, research have been written that actually I read this publication, these surveys, and it's quite often reduced to just game with philologic notions, with words. I cannot say that I would not survive without this term, but since I come from academia, I am sure that everything should start with the theory. I bought 3 textbooks for ethics, on ethics. I read one already, because actually integrity is a part of it, because our legislation has not only term of integrity, it has always operated with the word good faith. Parties in good faith work in good faith, so we can continue these synonyms in good faith, integral, honest, etc. But in fact we are talking about a moral, ethical category, which we are trying to define in a legal way. Should all these notions be stated in the law? Probably not, because we have moral norms, religious norms, and they're not part of any law, but that's why they have these names, moral and religious. But here we are talking about attempts to present these notions through the law. I know whether it's good or bad, but in this country, the integrity now is at the level not just law, but the Constitution. And that's probably a good reason to be proud of our Constitution, but what was the reason to escalate it to the level of the Constitution? And of course, when I just read first out of 3 textbooks on ethics. What I understood that integrity is about ethic behavior. Everything started with Aristotle and his ethics. All other things that were invented just repeat Aristotle or criticize Aristotle. So, what do we mean by an integral or honest person? That's a normal individual, just normal person. And when we talk about integrity, why are there so many questions? How to define it? I mean, here we had a number of features, characteristics, like personal features, personal characteristics of individual. But we are talking about just a normal citizen, normal person. And probably that's our strategy, maybe not even the strategy. It's very hard to describe a normal human being. I mean, normal individual is when everything works in his soul and body. So now when we define integrity, we proceed from criteria of non-integrity. We say they are not integral because of failure to declare. I mean, the law cannot regulate all cases in our life. There were precedents of this kind in the ancient China. They made an attempt to regulate everything. In Europe, in Austria, such attempt was made. They tried to prescribe in civil code how many times a woman should feed her child with her breast. I mean, you cannot describe everything, so the generalization is needed. But still, there should be some space for discretional evaluation. It's not possible to do everything exhaustively, because otherwise we'll have to have many terms of books. I mean, it's like in medieval times, the church tried to do it, to describe all virtues, but still we need to work on it. It's a very serious matter. We need to develop some general approaches and concept of the fact that we are discussing it means that we are making steps to really overcome any lack of integrity. Thank you. Thank you, Mikhailo, for these very opportune and relevant comments. I wish you to read the remaining 2 books sooner, then you can write yours, where you will share your thoughts, which is also very important to have balance of opinions, so that we can engage the public authorities, NGOs, international organizations in the discussions. So to do it, I will offer follow Poroshenko, expert of International Organization for Development of the Law, because when we talk about integrity and all these competitions for positions, we often mention international organizations, and we invest a lot of trust in them. So Denise, the floor is yours. Are we ready to do it at our own, to screen out non-integral and integral individuals and other international organizations really ready to help us in this area? Thank you, Larissa, to answer your last question. Certainly yes. The Bureau of Technical Assistance that I represent, our international partners and donors, are absolutely open to continue supporting Ukraine in establishing the culture of integrity, in educating integrity in civil servants, until we say we can say that all these public authorities perform their functions properly and contribute to the development of tradition of the rule of law in Ukraine. I'm very thankful for these wonderful discussions, to all our experts who are present here, and to the Center of Political Legal Reforms. To be honest, I didn't expect that we would go such in depth in this discourse. First of all, Roman, thank you for your research. I will be waiting for this monograph. It's very interesting to read the conclusions. I mean, you analyze these 327 decisions, and that's a huge volume of work. So it's a good approach to summarize the practice, to develop common approaches, common concepts to ensuring integrity. And this is what we need to do, because if you analyze even the effective legislation, as Mykola Havronyuk said, and Eugene Dan said the same, that the indicators of integrity, independence, good faith, etc., in many cases they are the same. They mean the same, and they apply not only to judges or candidates to judicial positions or to members of High Council of Justice. These notions are already part of the law on prosecutors' office. For instance, they apply to representative of anti-corruption prosecutor's office, and to some extent they apply to prosecutors. These laws are already part of the law on Bureau of Economic Security. They apply to all of their officers. The same provisions exist in the law on National Anti-Corruption Committee. So it's time for the discussion on how we can unify these approaches to integrity. Well, I fully agree with Mykola, and we need to actually first find the very essence of the term before we try to define it. And it's not easy indeed, especially for Ukraine as a country that to some extent is still within mentality of post-Soviet system of law. So that's why it's very important for us to include that as part of the law. And it's important that we already have it partially. And I fully agree with the fact that we go from something opposite. We proceed from something non-integral to identify those prosecutors, for instance, who match this characteristic, match this feature. We are a unique country in this regard. I know Albania took this approach. Moldova is now trying to follow the same path. And with the time, I hope we'll switch to positive definition of integrity, as they do in developed democracies. But still, I'm sure we'll do that. But I don't know how much time we will need for that.
Probably the last thing I will mention, that international experience, while assessing the integrity, we have to reflect not only the national background, but also the experience that we generated due to the other partners who were going this way earlier on. I did mention Albania and European Court on Human Rights in respect of assessing the integrity within those procedures taking place in Albania starting in 2015, and European Court on Human Rights confirmed that the assessment of active civil servants, they were reviewing the regular judges and prosecutors, that meets the spirit and essence of rule of law could be applied as an extraordinary measure and could take place under the adherence of some circumstances. And actually the discussion of these circumstances undergoing today and should continue in future, that is something that we should focus at, and we should reflect that in the legislation and in the subsequent decrees. So thank you each and everyone for today's discussion, for such a depth. We're grateful that there is an intellectual core pushing that subject, and it would be an honor and pleasure for us to support you in that and be with you. Thank you, Denis, and thank you very much for the recognition of our effort. I think that we can move further and consider the perspectives of unifications of these common approaches to integrity definition. And we have a representative from the National Police, the Anti-Corruption Branch, Oleg Lazovy. So, dear Oleg, we would be most grateful to hear what the National Police itself is ready to accept and absorb those approaches which we're talking about today, and whether National Police can share its experience in identifying integral or filtering non-integral candidates. Thank you for such a profound event, and thank you for such an open share of your thoughts and your deliveries. On my personal behalf, I would like just to explain how that happens within the National Police and maybe stress on some challenges and ways ahead. Today, if someone is nominated to the National Police system, that individual, according to current legislation and a respective ministerial order review, takes the polygraph review, truth detector review. That is something that could be considered as an integrity test. Other things that's based upon individuals' content. And if someone takes the managerial job as a promotion, this is a discretionary decision of the manager among other candidates to decide who fits the job the most, because they all equally know in legislation, they're all professional. But if they're seeking a different senior job, they volunteer to take a polygraph review. So, to see to what extent that individual meets the criteria of integrity. To my mind, integrity hardly could be defined by a single definition, because different institutions may be interpreted differently. But based on the National Police example, we have the norms of ethical behavior for police authorities. This is mandatory to adherence, and everyone joining the police is familiarized with these provisions. And if you read these rules of ethical behavior deeply, I will just quote few of those. Besides, adhere legislation, constitution, be professional in your job, follow the anti-corruption legislation, like respect dignity of each individual, be impartial to everyone, be restricted, be careful, be polite, control your emotions, have a decent external look. So if we would have a look at these rules as a set, so if a police official would adhere them all, he or she would be like an ideal person and ideal servant. And if we would be able to adhere these principles to a full extent, that would be completely integral police official and integral person. The other challenge, too much is written, but not everyone is clear how to implement it, how to make it happen in real life and be integral. Keeping in mind that the National Police has respective training and education institutions conducting the initial and induction training, those who pass the competitive selection. They are trained for 6 months in a police academy, and then they become patrol police officials, and then once per 3 years there is a improve of qualifications. So we decided to introduce the building integrity course for police officials, divided in 5 modules, and we took the basic as a baseline the NATO BI building integrity course and took that as an example as it has been implemented abroad. And we reviewed our ethical requirements, our legislation, and put it in a simpler terminology in that respective course and module. And we're going to introduce, starting the next year, 2025, introduce that course for all legal entities of the national police, the head office. So each and every police official on job would take this training, would get a certificate, and would be clear with the basic principles what to do and where to look. I agree, if we would put in written everything as it is written in the law, do such and don't do such and such, that would be easier, absolutely. But we have to action now and not to wait until someone will do this job for us. Thank you, Oleg. Fair enough. If we would put everything in each and every detail in the law, trying to cover every possible situation and every possible type of behavior, probably our laws will end up as 10 Bible provisions. We hardly can anticipate every situation possible in life, so we'd rather speak about principles of integrity, which should be milestones to guide officials, and that is something that judges and prosecutors and police officials could reflect on. Konstantin, we see your hand in Zoom, but I do apologize. I still would like to give a floor to our participants in the room, and then we'll proceed with you if you don't object. I would like to give a floor now, once again, to our international organization colleagues, and we have advisor on anti-corruption, European Council Advisory Mission, Kristina Talinimi and Bettina Nellen. And please, the floor is yours, maybe to reflect on something and share some experience from your respective nations, or just to share your observations on implementing the integrity in European nations. Bettina, please, the floor is yours.
Yes, hello. You will translate in Ukrainian? Yes, okay, sure. Okay. Yeah, good afternoon, and many thanks for this discussion. I think it's very fruitful, and I would like to introduce myself shortly. So my name is Bettina Nellen. I'm a German lawyer, but I worked more than 15 years in Luxembourg and in the financial sector as an anti-money laundering unit head, and specialized in detecting beneficial ownership in offshore companies. So I would like to add, maybe related to the judges and prosecutors, integrity, and also coming to the political exposed persons, because when we go to the higher judges, we have political exposed person, and I think the Ukraine managed already to register the PEPs here. So there is a registry where you can find those persons, so parliament members, and here let us go to the judges from higher courts and high prosecutors. These persons have to declare their assets, and I think it was mentioned at the beginning. For me, it is very important to add also declaration of assets mean also to make their bank accounts transparent. So it is easy, of course, if I have a bank account in the name of a natural person, in my name, I can declare it, you will find the money on it. But it is very tricky when it comes to legal persons. So if I would like to hide something, of course, I would build up a company, bringing a bank account in the name of the company, buying the directors to represent the company, and being really the beneficial owner, ending up in a trust or in a holding or whatever. So, and here it becomes very tricky because you can hardly control this or find out the beneficial ownership without having special knowledge. You might have special tools, and normally the cooperation is with the financial intelligence unit. So they will receive normally the suspicious transactions, they will collect them and then will forward them for prosecution or whatever. So, and for me it's very important, and I would like to know if anybody could provide me an answer, how proactive really the collaboration here is with the financial intelligence unit, and if there is really the control or the verification of the PAPs related to those declaration of bank accounts, not only for the PAPs itself, also for the family members, meaning children, mother, father, and so on.
Thank you, dear Bettina. Well, you might not be aware to an extent we're a very peculiar state. Not many people keep their money in the banks, but they probably dig it somewhere in the backyard, in the canisters, or keep it under the mattress. That might be quite often the case. Well, yes, true, we did have such an experience of imaginary corrupted judge who had money in the banks, but not in the financial banks, but in Ukrainian banka, it's the can, so in cans. And we have online a colleague who would like to join the discussion, Valentin Karakos. He is a judge of the court from Donetsk Oblast. Sir, can you hear us? Good afternoon. Yes, I can hear you, absolutely. And thank you for giving me the floor and possibility to join the discussion. I just would like to reflect as part of the ongoing discussion, and probably my reflection may be of use, because I'm a judge who passed all these mentioned procedures. The first thing I would like to mention, there is such a thing, that integrity, what does that mean? In a daily lexicon and in a daily traditional language, it was absent till 2014, completely. And it's very important to see how that is seen by the judges, by the civil servants, by law enforcers, how that word has been introduced. And I would like to mention that the first, when the amendments to the Constitution of Ukraine on the justice, that terminology has been introduced in a constitution. So it would be very important to get some common understanding, or maybe an explanation from the Constitutional Court. But there was no request of that sort. How do we define and how we interpret the integrity for the courts and judges? It is absent. And this is a similar case with many institutions in terms of the public trust and confidence area. Absolutely fair comment in respect of when we review the integrity issues, what sort of questions do we ask and what sort of answers do we provide. That is probably the first challenge here and the first problem, because concerns in integrity were seen not as the concerns because of poor understanding of criteria, but that has been seen as the category whether the civil society or institutions which are not related to the respective authorities to pose these questions. And I think we passed that Rubicon. And for quite a long time ago, the judicial branch had passed that. So I think we have to develop certain standards of interaction, so it is not going to be a pure issue of integrity for the civil society introduction, but there should be a judicial community also to introduce these standards. And when we had the session of judges, when we endorsed the code of conduct and among other official documents, there were things mentioned as the judge's mission, those who wear the court powers, and the code of conduct for judges that was voluntarily acceptance of certain restrictions. Before that, there were no document of that sort at all. Why I believe this document is a revolutionary? I will later on get back to the list of literature suggested. And maybe that's a matter of history or philosophy. I don't have immediate answers, but I think it's absolutely worth to think together. The Quada is the Charles de Montesquieu who designed the modern system of checks and balance. So the criteria of access to power, the possibility to get access to power for an individual, separating private interests from social interests, why this power authorities were given to an individual. And that leads the way to a discussion, because what's going on in the judicial reform and court reform maybe lays more that we're trying to reshape the Soviet standards of existence of a governmental machinery to a democratic principles. But probably the first stimulus or the first source of power, the history of establishing the democratic institutions, is absent. It's not the case of theory of conspiracy or whatsoever. And all the authorities that governmental officials exercise, even in the procedural codes for judges, are written from the functional point of view. So sort of mechanical adherence. It's not the matter of mission and vision and strategic definition of motives to exist for prosecutors, for the national police. So it's not there in legislation. And I think if we get back mentioning the integrity issue, not like a red lines or restrictions or absolutely integral behavior or non-integral behavior, I think we should reflect the communicative case of former state funds who was the whistleblower for several times and who said few steps, who was publicly known, but nevertheless he was then suspected by the National Anti-Corruption Bureau that he also was the participant of corruptive schemes. And I do operate these facts from the open media sphere. So these are the extremes that people can play with, manipulate, and even unconsciously. But while we're speaking about integrity as a category, as a constitutional category, which should be the operating principle for a governmental department, for a court, a prosecutor's office, or police department, ministry, or agency, I think it's critical to understand why, what for which governmental mission, or to satisfy which social good this agency has been established. And I think this function could be defined not as a rule of code of ethics, it should be defined as a mission, just physically, around which people can build up their behavior, not even trying to get to red lines, but adhering to the standards which to their belief should be adhered to follow that social mission which these missions were established to.
So I think that example of judicial reform is a good opportunity to work on our mistakes and, more importantly, to generate documents to be issued by the communities of judges, prosecutors, with identification of this internal culture, criteria, if I call them, yes, the community of the people who decided to devote their lives to this mission. Thank you, Konstantin, for this very opportune thoughts, especially with regard to formation of mission in the ethical codes, because if we look at the experience of civil society organizations or business associations, that's where we can see this common understanding of their joint mission, of their common mission. And that establishes foundation of the integral behavior, the so-called foundation for corporate culture. Now I'd like to offer the floor to the Deputy Head of National Anti-Corruption Commission. We talk a lot about integrity, and integrity is about prevention of corruption, because when most of your officials adhere to this principle of integrity and accept them, then probably you will have less corruption. And the integrity is one of the elements of prevention. Please, the floor is yours. Yeah, thank you for your invitation, for this opportunity to present our position, because I can say it without any exaggeration that actually the matter of integrity is now one of really fundamental notions. Of course, it's very hard to define it exhaustively, to cover all possible options. But at the same time, I think that we can work on clear definition of basic criteria and basic factors of integrity. That's what we can do. We certainly cannot list all the cases of non-integral behavior, but what we can really do is to name the criteria. At the same time, I'd like to say that if we manage to do that, that will be important not only for judges, prosecutors, for law enforcement, for competition purposes, for selection, for careers, but that will be very important principle for our future generation. First of all, for students of the law schools. Because if we have clear understanding of these criteria, I know that will have impact over the content of curricula. We can talk about education of prosecutors, police, whatever other words, but all that will be based on these fundamental principles, which will lead to their readiness for being evaluated on the basis of this criteria. This one of our function is actually the enlightenment, the education. So we are supposed to explain to the people on time what integrity is. We need to show the consequences of implementation of this notion for the future generation. And actually we we say that integral behavior is when you do the right things. So you need to understand what is wrong. So this is compliance with the provisions of the law. That's another aspect of that. We are here for having two suggestions for you. First one is my personal suggestion, and the thing is that I have my previous experience when I took part in the competition for the head of a National Corruption Bureau, the National Agency, Anti-Corruption Agency, and for some other positions. So actually all that was based on integrity criteria. So the competition for the position of National Agency, National Anti-Corruption Agency, certainly included more criteria because anyone, an individual within a background could actually take this position. At the end, the competition board developed a methodology including specific criteria, and I believe that was very good quality product. The methodology for evaluation, I will mention briefly those criteria. That nothing common with corruption or corruption acts, financial integrity, ethical behavior, compliance with the requirements of the position, and acting in good faith. So we can see here something about law, about being far away from any criminal activity, some parts of ethical considerations. So also there was methodology for evaluation. To put it together, they gathered information, collected information from NGOs, from previous employment of the candidate, from mass media, everything that could shed any light on such individuals. So it was really wide approach based on big number of criteria. The second suggestion for you is the product of our national agency. We want to present it today as a booklet. We have respective slides. You can use the QR code and you would be able to have this link, which will give you the link to this product. That product is an attempt to unify criteria of integrity for civil service. But the peculiarity is that it rather applies to categories A, or top-level managers of the government. I mean, those who have already had previous experience and previous background with the civil service or with law enforcement. So we developed 7 criteria, and these 7 criteria are covered through certain lists of questions. Why did we undertake this effort? Because we wanted to systemize criteria of integrity to help develop a common approach to all kinds of these competition procedures, selection procedures, so that the competition boards could take these criteria into account. I think it's a good development. There are 7 criteria that you can take for your consideration for further discussions and maybe adjusting any concepts that you develop. I'm not alone here. I have here head of one of our units, Alexander. That was his project. I want to give him the floor so that he maybe shares more details about this effort implemented by our agency. Well, thank you. I will explain very briefly. When we talk about integrity in the light of the current legislation, effective legislation, every time at every competition we see some discrepancies in the understanding of this notion. We check financial status, financial condition, income, the performance at previous workplace, sometimes without paying attention to the fact that all these competitive selection procedures differ, like here my colleague mentioned the competition for position of National Anti-Corruption Agency, and there were some peculiarities with regard to vetting and checking the potential candidates. So, since we're talking here about civil service, top-level managerial positions, probably we will not find any single notion dictating you what you should ask, what questions you should ask the candidates in order to make sure this is an individual who has integrity. So we try to put together recommended list of criteria based on questions that can be asked to any candidate. So we proceeded from the idea that the check for integrity, verification of integrity still proceeds from negative sides, so like whether this individual was, say, prosecuted or held liable for anything or involved in any negative activities or any negative experience that then would prevent this individual from taking this position. So the criteria this time are based on the legislation related to corruption, there's conflict of interest, unlawful benefits, or unexplained wealth, etc., and another set of criteria which actually is deducted from the ethical codes. This is what the public service is aimed at servicing your state, serving your people, your state. And that's the very foundation. So, no negative actions harming anyhow the state or the people of your state is admissible. Say, for instance, we talk about any negative statements, any, say, cases when unlawful advantages are granted to any of the parties taking part in, say, governmental work, etc. So these are the questions to be asked by those who will do the selection, competitive selections. That's of course not a must, we're not trying to impose it on you, but that's the frame within which we look at the matters of corruption and protection of the interest of the public. But they still can be helpful to the boards that conduct this selection, competitive selection process, and for purposes of checking the candidates. Just one more point to add. It's very important, please pay attention to the fact that the final conclusion on integrity of a candidate should not state that this individual has no integrity or has integrity. The board is supposed to evaluate an individual such as meets the integrity criteria or fails to meet integrity criteria, because every competition has its own criteria, and plus you then avoid stigmatization of this individual who once received this opinion that he has or she has no integrity. So yes, we can talk about matching some criteria for integrity, but not being integral or non-integral. Thank you, esteemed representatives of National Anti-Corruption Agency. And I can see a question here. Well, I wonder what you he mean by you use the word good faith or integrity. Sorry, it's so many. I mentioned this term as one of criteria for the competition for position of the head of our agency. And this is the term used by the rules of procedure of this commission, and the definition of this term is the candidate is capable of having positive thinking and acting in the name of the state, country, people, and peace. I understand that's very high-level definition indeed. For it can apply for the position of this authority. They are very important words, but when we talk about competition for position of a prosecutor or policeman, Of course, the wording should be different. During the competition, as far as I could understand what they meant, they asked questions like, what was your attitude to your subordinates? How did you deal with them? What's your priority, the result or the good atmosphere in your team? What values do you have? So these are the questions asked to assess me from the point of view of this criteria of integrity. Thank you. I really paid attention to this because, again, I apologize as interpreter, that's very complicated game of the words, like good faith, integrity, things like that, synonyms. But, well, now, again, I'm translating. For each of these 7 criteria, can you ask 5 questions under each one of the criteria? So you have 35 questions. What if somebody suggests 36th question? How come that happened? Was not in the context mentioned by Mykola that he said actually it's not possible to define very clearly and exhaustively ethical categories like integrity. Well, we are not numerologists indeed. We just made an attempt to make any systemic process. We have a criterion of integrity. We actually put together a clear list of basic questions through which each criterion could be assigned some number of points for rating purposes. It's not about numbering and mechanic, but since we are aimed at streamlining the evaluation or the assessment of the candidates, we thought about something simple that does not require any special sophisticated formulas to put together the rating. Okay, that's good reason for you. Thank you. Actually, I started my presentation by saying that that's not irreversible, that we still will need to identify the basic criteria that will have the fundamental meaning. For education of future generation, criteria of integrity and competence are inseparable now. We will have to keep that in mind. So yeah, the good idea was to get away from this proceeding from negative notions. Well, I have a question to you, gentlemen. Thank you indeed for this very important work. I just recalled one of the ways how you can check the integrity that's used in some countries. But I have a question with regard to indicators to develop criteria for integrity. Did you try to consider as the basis for these indicators the list of indicators as stated now in the law on judicial system and the laws on national anti-corruption agency, etc.? Well, you see, we decided to take a bit different path, take another way. We thought that now the integrity is viewed through some aspects, including as one of the principles of civil service. So I believe that the words like honesty, empathy, it's a category, but when we were putting together this basic criteria, the questions, we tried to take several paths, basing it on few main pillars. First, through the research studies of the effective legislation, We looked at the codes of ethical behavior, and we tried to understand how the lawmakers actually apply the notion of integrity to civil service, public service. I mean, and I see NABU, but all these laws deal with the notion of integrity, still having a number of basic similar approaches.
Сьогоднішній день
We say that through entire public service, the integrity principle has the cut-crossing features. We also took the whole range of reports from international organizations covering the issue of integrity, how that may be presented in a public service, because still we were more adherent to the senior management of the public service in our basic approach. And then the third pillar, these were the scientific developments. The most exciting part, to my view, understanding of integrity has a very wide aspect. It is seen both as ethical category, and you can find the respective theses and paperwork where integrity is part of ethics, and vice versa. Ethical conduct and ethical behavior is part of integrity, and it's difficult to find a stole way. That has been reflected. And at the same time, we constantly were returning to our authorities and our basic requirement, that's integrity, in the light whether the person can explain his or her past incomes, previous jobs, whether there was a conflict of interest, whether a person has been convicted for corruption, whether the person can explain all their incomes and incomes of the relatives, whether any actions were committed under pressure, whether any pressure has been committed. That's all according to the law. And secondly, we tried to do it in such a way so that could be also reviewed. So the board or commission, utilizing different tools, could review that if the candidate says that no previous actions committed, no previous engagements, but from the open source or by any review tools, by reviewing declarations, we can see that this answer is not truthful or complete, so it may lead to well-grounded doubts that this individual can be allowed to take a senior civil service jobs. And the whole set of these approaches, which at given moment takes us back to what we would like to see in the candidate first of all, and what are the legal requirements. Most of the jobs in the civil service are described by the legislation. We were trying to use these basic questions. I fully support that the majority of senior managers should have a significant amount of what we call the human features. So honesty, empathy, other set of kind of human features. But on the other hand, we are back to the question that we have a generic understanding through all the codes of conduct and a number of legal bills, the generic view of integrity, and also the legal requirements in different ways which we have to present to the candidate and which are worth to be reviewed. And we recommend that to the board, to the selection board, to pay attention and to build up the respective architecture of the review. Maybe there would be any more reflections. Vera, good afternoon. I'm Vera Nazarova, and scientific consultant to the judge of a constitutional court, and I also study the case of access to the public service, and thank you for being part of such a professional discussion. And I would like just to draw some practical issues of evaluation of the candidates or the judges in part of integrity and professional ethics. The challenge is, if you can recall when the ethical board was founded, it reviewed the acting members of Senior Qualification Commission and those who undertook the qualification review before, those who were reviewed for integrity. And currently the candidates for judges undertake this review for ethics, and if the ethical board or any other commission has the well-grounded concerns, this candidate terminates that selection. So well-grounded concern in a given context is not a very legal category. Yes, it is borrowed from the criminal law, but to make it authoritative for decision-making, preventing candidate to move further on the competition. So availability in the ethical board of well-grounded concern, which I would repeat myself, is borrowed from a criminal rule, is not authoritative enough, not authoritative definition as it is in the legislation. And it leads to the question on the quality of that legislation that regulates the selection and move of the candidate in a selection process. Secondly, the question for me is the doubtful. You probably have seen the interview of the candidates for the job of Constitutional Court judges, and quite often there were the cases that candidates before were the candidates to other respected authorities, and they were positively selected and they had positive conclusions on integrity, but as part of the Constitutional Court they end up not meeting the integrity requirements. So that leads to a question. Once again, I will repeat myself. The issue of integrity is more philosophical question that sits in the sphere of moral and ethical relations, and whatever we do here, whatever generic features we would invent, it's still called reinventing the wheel. If we will reinvent, that's fine, but still, you're either integral or not. And for me it's quite strange when the board says you are not integral in the context of meeting the job requirements for the Constitutional Court judge. So before, the candidate met the integrity criteria as the member of selection board, and here as a candidate for the judge he does not meet this criteria. So you're either integral or not. And your high moral features, mid-level moral features, again, that's doubtful for me. Let us then get back to the possibility to manipulate. Once again, we mess with the law here. Do we want to regulate more? Still, there would be enough gaps through which we may say, no, you do not meet the criteria and substance of your integrity violation is not significant or is significant. So again, that is a field for manipulation. And also it leads to a question again. You may have heard the Institute of a Business Reputation or Political Reputation. In fact, we're moving towards European legislation, and to my knowledge, that institute is in operation in Europe. And why at this given stage, why we'll review the integrity? Unfortunately, we can assess that in a different way. It may be the evolution of our right, or unfortunately, this is the threshold which we had achieved so far. And respective authorities of financial monitoring would be active enough in reacting to detection of some corrupt behavior of judges or whatsoever. As part of the special review, our candidates' review for integrity criteria would not be that monetized as it is now. An ACP develops their criteria Why? Because the integrity has been monetized. It's a criteria that you just have to demonstrate your state of income, brief how come your relatives were able to purchase something. It's all about money. And thank you very much for doing this enormous work. Probably it's like a single soldier fight, but again, it's a philosophical aspect which we're trying to fill with some understanding. But in fact, no one managed to reinvent it again. That's why so many misunderstandings in the process of candidates' evaluation on meeting the requirements. If we review the candidate for the integrity criteria, the entire procedure should be the same robust. If Commission decides that you do not meet the criteria of integrity, that should be a public decision, or there should not be certain buts if you would like to see that decision. So there are still many challenges ahead, many questions to the quality of legislation. And as I see it, my great desire and expectation is that that review for integrity would disappear. Sorry, colleagues, but we have the presumption of innocence, and I do have that we would have a presumption of integrity. Each official at every level should be considered as integral at first, and it should not be reviewed for integrity. He or she should be of that sort, but then if there are well-reasoned doubts, court rulings or claims from other individuals or any other evidences, only then the competitive board may initiate a special review based on the fact of violation committed. Because we put a stamp, a negative stamp on our society. We already consider citizens as non-integral. And with all my due respect to this audience, thank you for this work, but I do hope that once again, I'll repeat myself, our society would be integral at the first instance, and we will not need these inspections and reviews. Thank you, Vera. I see in Zoom your comment caused some excitement, and I will give the floor to the question. And then we'll get back to Zoom. I saw all your hands, but I think that when we will get to this state of presumption of integrity, we will not have reasons to get together and discuss that at all. And secondly, I think the investigative journalists would stay jobless. Yulia Kirichenko, you had a question. Thank you, Olga. No, it was not a question, but it's rather thinking on that. I probably would echo to have this presumption of integrity, but why we ended up with such a new tool of review of integrity? Probably because, as Professor Havronyuk mentioned, the criminal liability for corruption is not working, disciplinary liability is not working, so we will invent tentatively one more wheel for the bicycle. Maybe we should look at the criminal right, labor code, disciplinary codes, and existing disciplinary tools to be improved, but not. It's still there. We should not again reinvent the wheel expecting it will work. I don't have a question, but who reviews for integrity the members of the selection board, the public board? I'm from the society. But what if the public board is not going to be the public board? But authorities are enormous. Ethical board. Who selects? Well, there is a selection to the public boards. But who reviews them? Well, there is a voting. The voting for the members. But it is not the review. So this is a proposals reviewed by society. Yes. We have the members of our center there, and we keep an eye on our reputation, but this is not a prevention. It's a procedure. It's just a procedure.
Береться недоброчесних громадських організацій, і саме вони сформують. Я про те, що ми даємо великі
Публічні
повноваження.
явища завжди є в будь-якому питанні. Просто що ми ставимо на вагу? Ми ставимо на вагу побічні явища, які можуть бути, чи ми ставимо результат, як я вважаю, що результат від доброчесності, від цих процедур набагато вагоміший і кращий, ніж побічні явища, які можуть виникнути на цьому шляху.
Ні, я просто ставлю під питання. Тобто у нас є ці конкурсні комісії, там етична рада, які перевіряються, але от питання, чи вони перевіряються. Але так ми дійдемо до, там не буде логічного кінця. Їх, наприклад, хтось перевіряє, хто тих перевіряє, да? Тобто там не буде відповіді, як це зробити. Але реально це великий ризик. Наприклад, формування такого якогось, в якомусь конкурсі на якусь посаду до якогось органу недоброчесного. І навіть, наприклад, може бути ситуація, що ця комісія, чи там рада, чи група працювала, там хтось не прийшов, а потім розслідувачі покажуть, що члени цих комісій були недоброчесні. Ми про це думаємо. Мені здається, це теж питання доволі серйозне, яке, до речі, може торкнутися.
So apologies for a break. It's a hot discussion whether this required or not required. The presumption of integrity is something that we should consider for future, but at a given stage of Ukrainian democracy is a temporary tool. Moreover, why do I think it's a temporary? And thank you to our international partners for assisting us. But everywhere we state that it's an interim solution, and these commissions and these boards has international presence and will get to a different level of democracy development, and Ukraine would be able to shape its authorities. That would be the right integration way. So far, we're grateful to our international partners for helping us in the sphere of preventing corruption, reducing corruption, but as we all know, it's impossible to get rid of corruption, and none of the nations succeed in doing so. These are my thoughts on integrity. I don't know, I probably would wish all and everyone to go through these criteria, but later on we would be at the same development level, so we would be living in the level when society tolerates some things and people would not get access to the senior or mid-management levels. That would be the key. Thank you, Julia. And we have Vladimir Sushenko, advisor to a prosecutor general. Vladimir, floor is yours. Good afternoon. Thank you. Yes, you can hear me. Well, first of all, I would like to thank the organizers of such an event. Very exciting, I do hope useful, and for the possibility to take part and for the floor. I will just express few thoughts of mine, which came to my mind not today, because that area stays in my focus for more than 25 years, and some thoughts and convictions had been founded. What I would like to mention briefly, in a given case, please don't consider that and don't see my job as the right to express on behalf of the prosecutor general or the prosecutor's office. I don't have that authority at the moment. That would be my personal view as a researcher.
I will speak as a lawyer that has had about 50 years of practice, my professional experience of my life. So I'd like to say that as of today, this term of integrity that was introduced in our legislation, and by the way, I remember Yuri mentioned Mr. Vitvitsky, the federal prosecutor, of the United States who actually initiated introduction of this term into our legislation. But I need to say that the integrity is not a legal category nor a legislative category. It cannot be so. This term is borrowed from religious dogma. If you look at the history and read it, then that's actually the translation into Ukrainian of another term that is used in Christianity as innocence, actually. So any attempt to put into the frame of legislation all these criteria that we invent will never give us an opportunity to achieve an integral society. I agree with the previous speaker who said that an individual is either integral or is not. You cannot have different criteria of integrity. You cannot have some criteria, some integrity for judge, some for prosecutor, some for commission member, etc. Well, Mykola conducted good analysis of all discrepancies in our legislation. In fact, we are talking about the single profession, which is lawyer. It's the same profession with all respective requirements. I fully agree with you, my colleague, that integrity is rather about fulfilling your mission and respective selection of the people based on how they understand their mission, how they live with it. So this notion of professional ethics, which is a synonym in fact, should be taken care of by professional community. A lawyer should be responsible in front of himself and professional community, and then before the society, for performing his or her mission as a professional. What we do, we are trying to just improve, enhance the work of competition board. I used to be member of 3 competition board. Once I was even chair. That's what Yulia Dichenko said. Who are the judges? Who is the evaluator? So by the presidential decree, I became a member of the board for competition to High Council of Justice, and the criteria were a person with reputation, authority, etc. And what happened? When this commission finished their activities, he cancelled, the president actually cancelled this decree and appointed different people as members of this commission. So by one decree, I was recognized as an integral individual, somebody who deserves trust. But then that actually decree was cancelled, and the result is that I'm not. So I think that all these criteria in evaluation of the integrity should be conducted within the community, and an individual may become integral, may obtain integrity during all his or her life. For me, integrity is just 2 words: to do good, honesty, good for yourself and for those who are around you. Do honestly good, and if you do not do it honestly, then that's a different question. So when we learn legal system, when we learn from legal systems of many countries of the world and selection of personnel, let's say if you take Germany, when I asked them this question, how do you select the candidates for judicial position in Bavaria? I asked this question to Deputy Chair of the Federal Court. He said, we actually checked this individual for 3 years. I asked, what do you check? We check everything, not the facts, whether he paid something bills or he bought a car. The integrity is the life of a human being, the very essence of this human being. So he said, we collect this information for 3 years, and then this information is evaluated by the judges. We have special commission composed of judges who then analyze the whole life of the individual until he or she stated about his desire to become a judge. And the judges actually approve the decision whether this candidate can become a judge. That's very serious and responsible activity. Even in Bavaria, they decide that this candidate does not match the criteria to be a judge. This individual will never become a judge in no other land of Germany, because judicial community will be aware of that. So maybe I will disappoint you to some extent. Your conversation is very important. The discussion certainly needs to continue, but we have to apply great effort to educate our society, because the integrity comes from integral society. Non-integrity comes from non-integral society. I agree. In law schools, we need to take care of this education. And I have this experience of how you can teach the subject matter that I actually borrowed it from Americans. That's the subject matter called professional responsibility of a lawyer. So I tried to explain to my students, to make them think, to make them reflect on these things, to consider them. That's how you start the education of the integrity in this context. Do good to you, to yourself, and to those who are around you. That's all that I wanted to say. We'll continue the discussion. We still do not have many traditions. We are missing many things still in our society, so we certainly need to continue this effort, and the Center for Political and Legal Reforms, you certainly must continue this discussion, but do not restrict it with the legal community only, with lawyers. We have other problems. We have this scattering of lawyers. Just see how many bar associations we have in the country. But you see, this evaluation, or let's take the United States or the United Kingdom. I like their selection system. The children out of 5 compulsory disciplines in the law school, the compulsory, not optional discipline is professional responsibility of a lawyer. And actually that's probably one of the most complicated matters for a lawyer. I'm really concerned with the fact that today we mentioned Bangalore principles. I think that these Bangalore principles would be good enough for evaluating, not checking, not vetting. Vetting and checking is just a formality, but it's through Bangalore principles that the judges, lawyers and prosecutors, all of them can be assessed on the basis of these principles. Thank you, Vladimir. Unfortunately, we've exhausted our time. Yeah, I apologize for maybe taking too long. Well, your thoughts are very Elefant Konstantin, we apologize too, but we ran out of our time. So just to summarize, I'd like to say Vladimir actually kind of made our discussion cyclic. So our general goal is to certainly increase the overall integrity in the society, and probably rather than discussing about unification of criteria for integrity, we should talk about unification of the very notion of integrity. And as we could hear today, indeed, that's a question that is still not answered in the legislation, but not even legislation, but at the level of philosophy and ethics. I'm very thankful for your thoughts, for your opinions, for your presence at this discussion, and I'm really thankful for you for starting this discussion, and I do hope that sooner or later, maybe through the unified indicators, we will conclude that there is no more need to really verify somebody's integrity. Thank you all. Glory to Ukraine.
Модератор це.